Oh my gosh, welcome, welcome. I was trying to pull up my notes over here and I wasn't quick enough. This thing went off the screen. So, hey guys, welcome to Outpost Gray, a YouTube channel designed to provide you information in cybersecurity, technology, and innovation. I'm your host, Jack Scott. And if this is your first time here tonight, thank you. I am so thrilled. Make yourself at home, reach out to the community. We are a community here to help one another. If that's to break into the industry or pivot because you're already in the industry and maybe you want to move from red team to blue team, that's what we're here to do. So really excited about this live stream. But before we dive in and I start telling you about the guests, some really quick admin notes. You guys have already started commenting about it. So I'm really, really excited because Outpost Gray hit 400 subscribers today. So huge round of applause, virtual round of applause. I couldn't do this without you guys. So thank you so much. I see I'll call you guys my repeat offenders that keep popping in here every week. You guys have been my try and true. And then I love when I have new people come in. So do me a favor, if you're loving this content, make sure to like the video, and then even more so, to mean the world to me, share it out with others. Already from the post today, I've already gotten another 4, I think it was either 4 or 5 new subscribers to the page, which that is amazing because what I do and why I create this content is for all of you. So I love the feedback and thank you for the support. Another admin note also is there's going to be some big news that's going to be coming down very soon. I can't really tell you much more. Just be prepared to have a shift with some of the outlinings of the show content. It's going to be for the better. So I'm really, really excited for this great opportunity that's been afforded to me. And I'll share more with you as it comes down the pipeline. And I think that covers my admin notes. All right, so let's talk about our show today. What are we going to be talking about? Technology law. Boring, right? No, not today. Not until you wait till you meet our guest. She has over 2 decades of working in the technology space. I am so excited because if you guys don't know me, working in the congressional space within cybersecurity and understanding the laws and the direction that we're going as a country, I'm really, really passionate about it. I think a lot of my passion is driven because I've spent 18 years in this space. A lot of it was in the military or the DoD sector. And then I moved into the private sector. And then I started seeing some of the disconnects we had between the private and public partnerships. And I started seeing that how laws were impacting the public sector versus the private sector, but even more so, how those laws are going to impact our security as a country, as a nation, as a cybersecurity community. So today, what I'm going to do is I'm going to really dig deep with our guest, Jennifer Sanders, into technology law. We're going to talk about, and we're going to break it down by looking at the current perspectives of technology law, what that impact is today. And then we're going to take it a step further, and we're going to talk about the future perspectives and what does that look like? How is technology law going to start impacting us in the future of cybersecurity, technology, innovation, all of these unknown spaces that we don't even know what they're going to look like in the next 3 to 5 years. And then finally, if we have enough time, which I will make sure that we have enough time, we're going to talk about the Section 230 of the Communications Decency Act. Now, if you don't know about this law, you will definitely want to listen to this because this is an area that has a lot of contention right now in Congress. And it's an area that is going to shape the way that we do social media. So I won't dive too much more into that because that's going to be talked about with our guests. So without further ado, let's go ahead and bring Jennifer on the stage. Hello, how are you? I'm so excited to have you, Jennifer. Are you ready for this?
Yeah, I am. Yeah, ready.
I love that hair. I love that hair color. I love that hair. That was the first thing I saw. I'm like, what is that? That's a pink, right?
That's a pink. It is a pink, and it's like semi-permanent. Yes, it's there. I was like, do I do this before an actual legal interview? And I was like, you know what? Got to be me. I'm senior enough. I can do that.
I love it. I did my hair pink a little while back. It's on one of my other shows that I did. And it was with a really well-known hacker. And I hop on and I'm like, I guess, because in the cybersecurity community, a lot of the hackers, red teamers, they have like colorful hair. So I'm like, I guess I look more legit. But being an attorney, I mean, how does that, I mean, you've been in the space for a while, but how long have you been coloring your hair?
So this is a newer thing. This is a few months old, but to put it in context, good question on this. So the way I look at it, I'm senior enough, I'm allowed to do this now. If I was junior, I'd be much more concerned about it. When we started my legal career, we were like, is this pearl too big in our earring? I mean, literally, is this little diamond too big? You know, we wore nylons because again, it was 2 decades ago. One of the female partners of one of the biggest law firms out here on the West Coast, she was one of the first female partners, and we were at an event and we were talking. She was like, no, we're still informal. You know, we still go formal, but I can wear the dress. This is a message to people. Like this more casual dress is the message that I'm senior enough. I can do that. You can't. And so ever since then, it's been and I do hear from people that the whole hacker community has colored hair and cats. So I fit right in. And the other one is a super funny one. I like to see when people are reading agreements or not. And I can put, this will get a laugh out of you. And the person who I did it to knows. But I was updating one of their templates, and I knew that this company had colored hair. So they don't need this provision, but they have it, which is a protected. We comply with all of the federal requirements around who you can hire in equal employment, and it's age, ethnicity, et cetera. So I just updated that clause for them and put including haircut. Like
Oh my God, I love that.
Put your color in there. They're like, I read the contract, and I'm like, did you, or did you just skim it?
Oh my gosh. Do they have to have natural hair color, or are you allowing like?
They don't discriminate based on hair color. They don't discriminate based on age, ethnicity, blah, 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 all whatever that template term is. I just slipped in hair color,
Man, as somebody Asymmetrics is ratting you out over here. You have plenty of cats, I guess.
What the hell is asymmetric?
I don't know, but they definitely called you out. I have a cat too. So cats are great. They're awesome. Mine's like a dog. So he's a hot mess. He woke me up yesterday at 5 a.m. and I just got up and started working. So I was like, I guess it's time to get up. But enough about cats. Let's talk about you and your experience. Take a few minutes, Jennifer, if you would, and share like, how did you get into this space? Like, how did it all start for you?
Oh, I was born in a neighborhood. I got into law. So I got into law I went to law school. I think everyone of my age, this will hit people. We watched Perry Mason, and that just got us excited in law. Of course, that's nothing in that. It's realistic. So I went to law school, and this is before law schools sort of majored. They didn't really have areas that you could focus in, and they definitely did not have tech back then. So I started in environmental, which I can tell people, unless you really are going to practice for an environmental agency, that is not a lot of fun. It's like tax law. In fact, it's worse. Sure. But luckily for me, the firm loved me. So I practiced at one of the largest firms was the largest firm in California. So it was Pillsbury, back before a bunch of their acquisitions. And luckily they had faith in me, and they put me in another group, which was business, which at that time owned the IP group. So this would be late 90s, I started in IP and trademarks. And so luckily back then, this is before tech took off, before the 90s and 2000s and everything else. So luckily I was in the right place. I'd say right place, right time. That worked great. Learned a lot there, started the IP licensing track, got burned out by the big firm, obviously. And unlike other people who were a little bit more worried about it, I just quit and went to work for an event planning company. Oh, wow. So the good and the bad of that, obviously that didn't work out for me. I didn't like it. Did great there, but what you learn there is the business side, which you do not get at a law firm. So that was an interesting experience, but a great company. You really learn what matters and what doesn't. So huge, really good experience. Then went back into law. So started at, and then this is something for people coming up through the, as you said, like advising people. Networking in your friend group is everything. You can be, equally qualified for anything, but you better know somebody at a company to get in and get in that stack. So a friend of mine who I think is watching this brought me in at Sun, and Sun's, back when Sun existed, in their professional services group, which again is heavily IP based. So from there, I've been in tech ever since. So it's been a couple of decades, and I've been went from there to Veritas, Plumtree, BEA, Oracle. Most of those through acquisitions. I'm not a big hopper. Viacom, so media. So Viacom, Nickelodeon, kids, media, online. So all the privacy stuff, and also started privacy early because I supported the marketing teams as well as product development.
Mm.
And that was back when they're just starting all this data stuff and all the, what you can do, who you can advertise, what data you can collect. So I've been in that again for 20 years. So, I think a lot of people like that, the J curve, are super curious. We like to keep on top of things. We like to keep at the cutting edge. And I just love that. And as you said, where are things going? What's real versus what's just out there?
Yeah, so you've got such a wealth of experience in the space, and with all of the acquisitions even taking place now, I think I saw the other day Cisco has proposed an acquisition to Splunk for 20 billion, which we'll see if that goes through. I mean, we're seeing acquisitions constantly, which changes your own personal scape of being in in technology law. So currently, one of the areas that has been really influenced is the cybersecurity insurance space. And how is that? Because, it wasn't a thing a few years ago. I remember actually being recruited in, I think it was 2000 and gosh, when was it? I'm trying to think. Before I lived in Las Vegas for a while, and it was a firm get it started. I think it was 2018. They tried to recruit me for cybersecurity insurance. And I remember laughing at the idea. I was like, who's going to pay for that? And now, yeah.
Yeah. I have a lot of thoughts on that one. Yeah.
Yeah. But then look at us today. Now we're in that space, but now there's so much there, because back then they were just trying to get people on board just to get like, here, I'll give you insurance. So what are some of the areas that you've seen recently from your time and to like current time? What are within being in cybersecurity insurance, how has technology law started to impact that space?
Yeah, and I'm not an expert in the cybersecurity insurance, but I have a lot of broad views there. So cybersecurity, as you said, the insurance started. Ex-boyfriend who was in the insurance industry, and they were one of the first companies, or they were early on that cyber insurance. And a lot of that started with restaurants who had claims because people were stealing people's credit cards. And so that actually came under cyber insurance. So they were starting and trying to do it. And so it has evolved, as you said. It's something that wasn't at anything. And I would say it's in the last 5 years, is my understanding, it's really taken off. Obviously, with all of the, everyone hears the news now, they're getting hit, and it's actually I think it's a loss leader right now. And the evolution that they've seen along with any industry, this is fair. It's not like this is new and different or anyone's stupid, is that it's, or anything else, is that it's an evolution. It's a new area. So it's a newer practice and risk area. So there's not enough data out there for insurers to adequately measure this risk. But also what they did before is they would just offer the insurance without evaluating the company. Then as you get more robust, you start these checklists, and every company just signs off the checklist and sends it back, whether they do it or not. And so good question is, what happens if you are then going to make a claim? Do they go back and go, did you have those practices? Yeah. And if you didn't, we're not, it's still unclear as to whether they would. I think different insurers are handling that or how they're approaching that differently. But we've evolved from the checklist now to companies that are actually looking and working with their companies. So a good insurance company or a good agent is going to work with the company and go, okay, what do you really have? And they're going to actually verify. So that whole trust and verify and go, oh, you have these practices. Are they actually implemented? Are you actually doing them? Do you have your incident response? Do you have your two-factor, 2FA, blah, 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 whatever they want up front. So you'll see, so it's an evolving area. And again, the insurers, as I understand, are looking at it, they're getting more data. This will evolve. They'll be able to model algorithms on the pricing. Mm-hmm. But you're also seeing things like this recent Merck claim where Merck and the insurer, our friend Dave in the insurance area, can give you the reasons as to like which pillar of insurance ended up paying,
they paid out.
But the reason that they ended up, the insurer tried to say that this was an act of war, and that thus the force majeure clause didn't, negated their liability to pay here. And as an insurer in cyber with that much coverage, that should have been a more buttoned up clause. That clause probably should have been 2 pages long. And I see this in tech agreements with vendors. You're still going to have, outside in insurance, it's going to be even more important. But you're going to see it like with your vendors. Force majeure is the clause at the end of the agreement that's in the miscellaneous 10 things that mean nothing that no one ever looks at. That was nothing clause until the pandemic came, and then it got some heightened. And now with cyber, it's again back high on the radar, and it's a clause that says if there are acts that you weren't aware of, that you couldn't foresee or don't have reasonable control over, you can you aren't liable to complete your duties under the contract. And those are like acts of war, acts of terrorism, natural disasters. Those are the words you throw in there. So with the Merck Insurance one, they tried to say that the cyber attack is an act of war. And the judge in that one read that clause narrowly and said, no, you should have said cyber. Act of war doesn't cover this. It's not an act of war. We're not at war. So you want to go to these. I now put in espionage, cyber attack. I put all this stuff in, and it's up to the other side to try and take that stuff out.
Yeah.
Because I want it. Right now they don't even claim that it's an act of war. It's all espionage, which is not an act of war. Because we don't
that
want
is
to go
really interesting. I didn't realize. I was just doing a research paper on NotPetya, so I was familiar with the Merck case, and because that was it. I just posted the link so everybody sees that they won $1.4 billion in the lawsuit over the NotPetya attack. But I didn't realize, I didn't dive deep into that because mine was really focused on how it initiated, which is Ukraine and the MedDoc and the supply chain attack that happened and it spread. And they accidentally took Merck down, is how I was understanding it. But I never read anything that fully defined it as an act of war. There was speculation and researchers were saying that, but no congressional leader, nobody actually stamped it and said this was an act of war,
And if my understanding, and so don't quote me on this because I'm not a diplomat and I don't have it, but I've heard people speak on this, is that we don't want to say it's an act of war because that escalates the whole thing to hot war versus cold war. So right now there's a lot of espionage going on between nation states. It is. It's a lot of the Russian, the hacks that are going on right now are nation state backed, but it's espionage, and we do these to each other, and this has been going on for a long time. We don't want to say it's an act of war because then that escalates it to a hot war, right? So, and also, as you noted, NotPetya was aimed at Ukraine, right? But it bled out. And this is where people, like right now, we're looking at what's going on with Russia and the Ukraine, and people are saying, well, that's between them. We're not going to get hit by those cyber attacks. It's like, no, that malware got out. That got out. So yes, we do need to pay attention here.
Yeah, it was the largest breach at that time in 2017. It was the most catastrophic breach that had ever happened. It was billions of dollars in damages. 60 plus countries had been impacted by it. And you crippled one of the largest shipping companies in the world, container companies in the world accidentally. So it's when people say I won't be impacted with it, they're not that's the lack of understanding that we're in such an interconnected world now that I feel like it's almost like people, like everybody's connected, like to Tom Cruise by 3, you've got that distance of 3. And I feel it's very much like that in the network, in the cyberspace world. We're all interconnected in some way. If you start going down the vendors and the third parties, one person's going to be hit. Everybody needs to start examining their network to see where are my vulnerabilities, because you could possibly be impacted by it. You don't know, especially with the stuff that's going on in Ukraine.
No, that brings it up. If it's a supply chain attack, it's going to be in anyone that's using that vendor, right? And it could be something that's latent, so you don't find out about it till much later. So again, looking at those relationships, and everybody's connected, and everybody, we've got internet. It's the internet, so it's traveling at speeds of light across, back to technology. And then you've got all these okay, now it's my supply chain, so I'm gonna look at my vendor agreements and see where the liability is. And it's like, that's after the fact. That's way after the fact. That's sloppy. Your contracts aren't going to save you here. You'll be in litigation for a billion years trying to, get anything back there. So yeah, everything's connected, and in security, it seems like this community is people work together. People really want to help each other and bring each other up. It's not like we got the best idea and we're not going to share it.
Yeah.
So it's a great community.
3 degrees. That's what I was thinking of. We're all separated by 3 degrees. So going back to something you said though, liability, we were talking about this when we did our pre-show planning on this. And I want to dive into it because it's something that we're seeing more and more of. Is there's a lack of education around what is the liability of my organization, but even more so, like Jennifer, why are people pushing off liability to, say, an insurance company or to a vendor? Like, why is that happening?
And this is a good one that I see, and I find this is going to be the new area. So back when we had, this is going to be the new cottage industry, we're going to have all the attorney specialists. Back when open source first started, when we first started having open source communities, it was a whole cottage industry. I was one of those attorneys. I supported the open source that was used in all of our products because I'm a product attorney. Then you come into cloud, right? And we have new cloud terms. So now you're looking at security terms. And so attorneys are looking at these and they're going, we're going to push the liability over on this guy. We're going to push it down on our vendors, make sure that they're liable. And it's like, that's not the way to approach it. The way to approach it is we're partners. Who's in? What are we doing? What are our vendors doing? What's the integration? What are the what's the dependency? What is the product? So what is it? Is it Slack and Slack goes down, or Slack loses all of its information? That's huge. You need to have like upfront some very good understanding with Slack and how your company's using it and dependencies, or is it some useless little who knows what tool? But you want to understand these up front. So with the liability, you've got attorneys negotiating contracts in vacuums, still not working with the business or their partners or the product teams or the procurement teams or whoever's using that, whoever's closest to it. You need to work with them and understand the dependencies, integration, data flows, access to networks. And from there, define the terms. So what I still see repeatedly are these terms that are useless, broad or useless. So we'll come across disaster recovery, and it's one paragraph, and it says you must have a disaster recovery plan, and you will implement it if there's a disaster. And if there's a disaster, that doesn't negate your obligation to use your disaster recovery plan. And I'm like, what the hell does this mean? Like, what does this mean? And I'm going to sign off on it because it means nothing. And whatever. But you want to work with the vendors. So mature companies are going to have InfoSec terms. They're going to, and again, make sure it's not just a checklist, because you're seeing a lot of this as we're talking about technology right now. You see a lot of people who, same with privacy policies, they'll just cut and paste, put one over. So you'll see pages, and I'm like, their InfoSec terms are far more mature and clear and well done than their contract, which is a red flag to me that one of these is a cut and paste. Yeah. So working, I like to get the teams, if it's something that's meaningful, if you're working with health data and you're bringing it over from Europe, connect those two teams, find out where that information is going, find out how it's going to be protected, what the channels are, talk to the, and if you're mature, talk to the business and go, why do we need this? What are we doing with it? Should we be capturing this? What are the protections around it? What's the offloading? We get rid of it so you don't have toxic liability. But so attorneys working together to understand, or working with the business working together, so you understand this. Because right now, a lot of them just go, well, that's fine. We've pushed it over on them. They're liable if something happens. But it's your company. It's your responsibility. That's your reputation. And good luck suing that little baby vendor over there who doesn't have the insurance because they just checked that box too. Mm-hmm. So, try to be a little bit more mature and work together. That's what you want to do, especially to your, we're talking about defense here. We talked about this as well. Is some companies, it's challenging. Like right now, big companies are very aware of this and have teams for it, but mid companies and small companies are either not aware of it. It's definitely something that's resource intensive. So if you are the bigger, more mature company, work with them, help them develop these policies, right? Rise all ships.
Mm-hmm. Got it. I love that. Rise all ships. Let's talk about, you brought up something I want to touch on. You brought up the Europe and bringing over data from Europe, which we get into. That's a whole other topic, but I want to touch briefly because I think it's useful, especially for anybody that's in here. We've got, just so you know, we've got people from Saudi Arabia and Europe watching right now, and also US. So let's looking from the lens of the United States and how we view cyber law and how it impacts us and how we operate very different than a lot of countries, because we have to worry about GDPR, and then we've got the CCPA, which is the California Consumer Privacy Act. But we also operate with, multiple states, which all of these states that we have different, they operate in their own little cell, their own little bubble. But with that, then you have the big overarching, which is like FISMA, Federal Information Security Management Act, and we've got Computer Fraud and Abuse Act. So can you, in a high level, and kind of drill it down in the easiest way possible to explain how cybersecurity laws work within the United States and how complicated it is because we are individual states? Yeah,
let me separate those two things. So there's privacy, so there's data privacy and data security, right? Those are two different things. So as you pointed out, GDPR is EU's data protection law, and that has certain requirements on what you can collect, what you have to do, notifying the users. You have to notify the users that you're collecting the data, only collect the data that you've notified them about, and only use it in the way that it's that they've granted those permissions, and then they have the right to have it deleted or changed or anything else. And that's great. I love it. I love that the EU is going in a great direction. How useful that is. I mean, if you're a user in the EU and you want to have your data deleted or modified, good luck finding every company that has it. I mean, there's a lot of holes here. Also, having represented companies, if you transfer the data out of EU to anywhere else, you have to have either data protection agreements or model clauses, certain statutorily GDPR required terms. And again, I've represented big health companies where they just sign off on these terms and they haven't talked to their IT department. So I'm like, what are you doing with this data? You're signing off on these terms. You have no idea how this is being used, released, what data it is, et cetera. So that's one. Then within the US, so again, privacy. We do not have an overarching national or federal privacy law. As you noted, we have 50 states who all have different privacy laws, which California, as you said, it's now CCPRA, I think they were amended. California's is known to be one of the strictest. So if you're going to be doing business online, which by definition is crossing multiple states, you want to try to, usually you'll go for the most stringent one because it's just, it's easier than trying to figure out across states. So, but again, there's a balance here in how states are doing these. So you want to protect your citizens or your residents, as well as not be too detrimental to businesses. Because again, these are super hard to comply with. So, or can be challenging. It can be challenging, privacy. So again, and as you noted, they're going to be different by state. Then they're going to have federal requirements by verticals. So as you said, there's the FISMA, there's you've got ones for HIPAA, you've got ones in the financial sector, you've got different requirements, right? So those are the privacy regulations. So as a company, it's like spaghetti or like spider webs. Like, how do you deal with this? So then again, then you've got security law. So security is going to be like your breach notifications. Right now, they don't have, which again, different by state, different by who's enforcing, some banks are going to have one, as well as other agencies. So right now in the security area and overlapping to the data privacy area, entities who have broad authority. So FTC regulates unfair business practices. So they're using that authority, unfair business practices, to regulate entities who have mediocre security procedures and requirements. Because they're saying, look, you're so sloppy, it's unfair to your consumers. So FTC is coming in that way. SEC regulates, you have to make disclosures that would be material to investors. So to your either VCs, if you're private or public, to the shareholders. So SEC will regulate if you have such shitty practices that your failure to disclose them was material to the investors. And where you saw this one was a breach several months ago that there was a delay in the breach. I think they actually reported it somewhat timely after the executives learned of it, like maybe within the 76 hours after the executives were notified. But the actual breach and the IT systems, people knew of it months earlier, and there was no procedure or process requiring that they notify the executives. So that was the faulty, faulty procedures that they said, look, you failed to disclose your shitty procedures internally. And that's a legal term, shitty. But anyways.
I like the legal term. Yeah. And on reporting an incident, we're actually working through that on the federal side right now. And CISA, in the most recent executive order that came out in May, talked about reporting time. And the congressional leaders were trying to get something in the NDAA for this last term and in November, December timeframe. It didn't happen, but the reason it didn't happen is they couldn't define, CISA and other congressional leaders couldn't define what is an incident? What does that look like? Because that's another thing, is defining what is an incident. Because if you do every single time you have like a red flag that goes on your network and you're throwing up the flare, that's not right either. And sometimes I know when I worked in fintech, there would be times where we had an incident, and there was one that we thought was a legit breach, and it was an S3 bucket. We had a lot of data that was getting spilled out, but we realized after it took about 2 weeks, Jennifer, 2 weeks of investigation, bringing in a third party from like a firm like Accenture in, and it took 2 weeks, and we realized it wasn't an incident. It was actually a backdoor that one of the administrators in the UK had created so they could do updates on that. But what if we had thrown that flare up like that? There's so many factors to this that it's going to be very hard, but we need something in place. Like you have to have something in place for organizations to be like, okay, I think this is an incident. It could be fairly big. We need to report it. Like something needs to be pushed forward, because it goes back to what we were talking about earlier too, is like, then now we have to worry about supply chain. Who else is this going to impact? If what you were talking about, that organization, or let's use SolarWinds, for example. Let's say FireEye had sat on SolarWinds for a few months and had not brought it forward as soon as they did. Who's to say it could have been even bigger than it was? I mean, it was pretty big. I don't know if it could have been bigger, but because we don't even know the gravity of the overall impacts of that. But that's where it's like, that's something they're working right now at the congressional level, is like, what is that going to look like? Like, what is an incident and how quickly is reasonable for these organizations to report it and take action on it? And what's the reasonable time if they don't do it, that they have repercussions from it, like the organization not paying insurance out or something like that. It's going to be really interesting. So I'm curious though, like, okay, so we're talking about
I'm going to say, just to hit that, you're exactly hitting a big legal area, right? Which is everyone's saying, why can't they legislate this? Why, this right now, there's requirements between 48 and 76 hours to notify agencies, affected individuals, et cetera, if there's been a breach, or, it's depending on how it's defined, right? And again, these are different laws, different states, different verticals. And what is a breach? So this is why we keep hearing about things. Oh, last October, 3 months ago, there was a leak, or 6 months ago, there was something happened, a release. Because what is a breach? When does this trigger? It's like, what is it? All of the factors that you just brought up are challenging, and companies don't want to be liable. They don't want to tarnish their reputations. They're not jumping at the bit to report these. They don't want to report it, ahead if they're actually not going to have that liability. So they're, although there's the safety issues of, hey, what if it is something and it's like a disease? What if it's cancer? If you catch it early on, you can help and stop this. Versus if you let it get to stage 4, it's not. Now it's a nuclear war or explosion. So it's inciting companies, but again, if you're a business, I mean, there's a lot of concerns here. And also, just from a legal standpoint, law can't keep up with tech. I mean, we already know this, right? It's falling farther and farther behind. So it's, and we can talk about that in other instances, but it's how do you define something that's, if you're going to do it for law, how would you define something that's applies in all of these different instances? You can't, right? Law, when people are legislating, you have to be really careful, because you'll end up with externalities that you didn't intend, right? How would you say something in the airline industry versus something in the frozen yogurt industry? Like, what is a breach? What rises to that level? And the companies, of course, I mean, that's what Breach Counsel does, is they're going to go, first off, it's all confidential. And second off, was it a breach or wasn't it? We don't know yet. Who was impacted? We don't know yet. So it's tensions there, because it would be helpful to bring it forward. And that's why a lot of the some of the I think it's the FBI reporting is confidential, so at least you can report it, but it stays confidential, and then they can let other institutions, or potentially if something's running in that arena. So again, like with banks, as you know, it's challenging.
Yeah, like the ISACs that are out there. That's what I do love. Like, not all the ISACs work really well, but that's a great area where you can get specifically industrial based. Like, I was in the FS ISAC, so the financial sector, and there's an MS one for, I always call it military. I don't know what the M stands for military, but we get DoD military specific information in that sector. So, and it's all confidential. So you don't know who had the breach. You just get a notification that something took place. You get indicators of compromise. Typically, you can get, like, if it was a phishing email, it'll be a picture of a phishing email. So then you can go into your network and make sure that you don't have that vulnerability. So that does help. But you made a comment, I want to touch on it too. It's about like law and technology, and how I feel like law is like here and technology just keeps moving and moving further and further away. And it's like, it's not even really a cat and mouse game. I feel like the cat is, like, the mouse is gone and the cat's just wandering around, because law, technology and innovation is moving so quickly. I feel like law is just, it's like an afterthought. How can we change that? Or we're going to have to change that. We're going to have to figure out a different approach to this to meet those two things.
Yeah. we're not going to figure that out here. It's I would put it like, as you're talking, the analogy that comes to mind is like tech is going to be Elon Musk's rockets to space to Mars, and law is going to be that we're still in the Model Ford, literally. So figuratively, but it's not keeping up. So tech is moving exponentially faster, and you can't narrowly legislate something. So and to broadly legislate, how do you even define the arena and what you're trying to legislate? So that's why, if you look at privacy, I mean, that's why we don't have a federal privacy regulation, or arguably, like, they don't want to touch it. They'd rather just leave it. They say, oh no, states' rights. We'll let states take care of this. This is really their citizens. But I mean, privacy is all cross jurisdiction, right? So it should, it's really challenging to try and comply with all these different regimes. But the federal government, federal legislators are like, how would we touch this? We don't want to be offending our, funding bases, et cetera. And remember, tech is some of the biggest lobbying dollars out there. So this is why you'll see a lot of, stuff that doesn't make sense. But so seeing things try to keep up with tech is going to be fascinating. If we want to go over to Section 230 at some point, but that's that was from 1996. So 25 years old. Law is really an afterthought, I would say. I mean, you're looking at these, remember the hearings with Facebook? I mean, and the legislators, the congressmen are like, what's your revenue model? Advertising?
Oh God, yeah.
Yeah.
I like this. Technology changes so fast, the security tools can't keep up, and good luck at getting training. Yeah. And I think this is Tom. In the asymmetrics. I think he came in and changed his name to an alias. I don't know. Maybe it's not. If you're not Tom, I just called you Tom. Tom's really cool. You want to be called Tom. So I probably offended somebody. I'm sorry, asymmetrics. Okay, so let's pivot into future perspectives, because we've got about 20 minutes, and I want to make sure to touch on some future perspectives, but then I really want to kind of dive into Section 230 selfishly, because I love this area. But future perspectives, like we just talked a little bit about how far away the gap is from law and technology. And when we were doing our pre-show planning for this, you brought up something. I wrote it down. I might have wrote it wrong, but it says, what do you see for requirements for future reasonable standards within this space?
So what it is, okay, so a lot of the current security requirements in the security arena, what companies have to have is reasonable. You have to be, which reasonable is a contract term that you just qualify everything with reasonable, because then it's not enforceable, or it's very hard to enforce or interpret. And actually, this is going to play through a bunch of this stuff. But so 15 years ago, some of the best advice, sometimes you get great advice from law firms, but which was great. If something matters, define it. Don't say reasonable. So reasonable is used throughout contracts, and it's in laws, legislation. Define it, give examples, give analogies, so that it's much more clearly defined. Like if you want notice within a reasonable time, which again, a lot of these breach requirements are going to have some sort of an exception for within reasonable time, et cetera. In no event, you want to put in no event longer than X, or something like that. You want to define something. So right now, a lot of applicable legislation around security requirements is all reasonable or industry standard. And so what we're going to see, so that's where it is now, which is very light. And again, there are huge challenges in trying to regulate this and what is required. So what you're going to see, especially, it's not going to, legislation, which is too one size fits all, you're going to see it coming through industry. So through industry or trade groups, as you said, or legislative bodies. So you're going to have the two big drivers are going to be right now insurance, as we said. Insurance is going to have certain requirements that people have to sign up to and show, verify. And then federal, so DoD, but all federal, because federal contractors are going to be required to have certain practices in place. And so when that happens, that bleeds down to all of their subcontractors, who aren't just federal contractors, right? They're also in commercial industry. So that's how that stuff's going to be driven through. And then same as with anything else, you're going to have to watch and verify, because a lot of times these subs do just sign off on checklists. Yeah. And they may not even be, they're usually found out via whistleblowers, not even via the requirements and the trust and verify. So but what makes sense in an industry? So if it's industry driven, hopefully it'll be more specific and tailored to the need, to the actual risk. So, and you're seeing this with CISA and NIST, right? So you'll see more tailored requirements, which will be good. But it's, it's slow moving.
Yeah, CISA, I mean, Jen Easterly is crushing it over there. She's actually the keynote speaker for the Women in Cybersecurity. So keynote, I'm a big fan of her. Just throwing out, doing a drop for her right there. Let's go back to something you just said, though, for crud. What were you saying? You were talking about whistleblowers. Yep, whistleblowers and private, like the public sector. But I want to talk about the private sector. I want to talk about that, the whistleblower, and the importance for everybody to kind of understand that, why that person, that individual plays a key role, especially in the defense industrial base or the DoD space. And it's becoming more of a prevalent person because of the CMMC that's been rolled out, because the congressional leaders, when they rolled out the cybersecurity maturity model certification for individuals and organizations that are still doing self-attestation and are allowed to, one of the areas they started to really lay heavy on is the whistleblower and the False Claims Act. And now they're realizing the False Claims Act isn't weighing heavy enough in the court systems, because there's key words that are in the False Claims Act, such as knowingly lied or falsified their compliance. So if a CEO wants to admit that they knowingly did it, okay, then they can be prosecuted. But if they say, I thought that we were compliant, that's why I checked this box. But then you've got whistleblowers who are inside the organization. So I would love for you to talk a little bit about how are the impacts of these whistleblowers? What are they doing? How are they coming forward and they're being listened to? And then now the organization is being prosecuted.
Well, let me back this out a little bit. So just so people in the audience understand what the False Claims Act is, just to show you that difference between the Star Rocket and the Ford. False Claims Act is the Lincoln Law from the Civil War. And that's how old this is. And this is what we're relying on because we don't have current legislation. So that's how old this is. And what it is that you cannot falsify or make false claims to the government when you're contracting with the federal government. You can't knowingly make false claims in your contract. So that's what they're relying on here, saying you guys checked all these boxes, that you have these requirements and you have these backup plans and you don't. So they're relying on something that's one, when they find out that they don't have them. And if it's, knowingly that you didn't have them, I would assert that the executive, it's going to be imputed to him or whoever signed off on this. I can't believe they're getting out of the knowingly there. And where that theme is going, and I just want to do that point to the whistleblowers, is that one way to make companies more accountable, which is what they're doing, is they're raising that liability to the executive level and to the board level now. So if you don't have appropriate security controls, your board can be liable. That will light a fire under a lot of companies, just once it rises to that level. But as you said, so here we go with this. So that's one avenue. The other avenue is whistleblowers. So when federal contractors and subs are signing off, as you said, it's self-attestation. They're signing off these checklists and saying that they have these controls. They may or may not be found out. If there's not an incident, if nothing ever goes wrong, you'll never know that none of them had these controls, or you may not know that whatever happened was due to their lack of controls or practices. So whistleblowers are coming forward and saying, I'm there. They don't have it. So they might be ethical employees who are coming forward and saying, I'm worried about my nation, I'm worried about our security, or they can be disgruntled employees. So again, this is something for companies to be aware of regardless, but whistleblowers are playing a big part in bringing these forward. Like, you wouldn't find out about these failures and controls and security controls, et cetera, without people coming forward and telling you. It's an objective requirement. But so they are becoming a bigger, which is an interesting enforcement mechanism.
Oh, yeah. And they're more trusted than trying to do a prosecution in the false claims, which nothing. And I threw some articles in there for anybody who wants to learn more about the False Claims Act. I also shared one about DOJ is spearheading, trying to get the false claims to be the tool to hold organizations liable that are falsifying self-attestation. So it's definitely an area they're realizing that it's not working. So they're laying heavy on whistleblowers. I think it's going to have another shift though soon. Okay, so let's do a pivot because I want to cover Section 230. So let's talk about Section 230. So for everybody that's listening, Section 230 is a section of the Communications Decency Act. Now, just like Jennifer mentioned before on the false claims, this is another legacy law. This was created in the early 90s, so nearly 3 decades later, but it's still having impacts today on what we're doing on the internet. And at the core, it provides immunity from liability for these like large social media platforms, think Facebook and Instagram. And it's been there for a while. It was all over the news, and now it's kind of behind the scenes, but there's still a lot of legislative movement around it. So I'd love, Jennifer, if you could take a few moments and provide a brief description of this act and what it means to online social media platforms and why there is so much talk about this.
Yeah, no, this has not gone anywhere. This is like back front and center. This is Section 230 is part of the Communication Decency Act that in 1996, when this passed, this is designed, it's to protect platforms of communication. So like telephone lines where you're speaking across telephone line and planning conspiracy. Is AT&T liable for that? Because you were talking, no. So this is to protect platforms who are mere distributors. They're just creating an even field. So it's basically been called like the backbone of the internet or the beginning of the internet, because if these companies were held liable for everything that happened on them, you wouldn't be able to go forward. So the 230 distinguishes between publishers and distributors. And publishers, so like if you, publishers would be your magazines, your whoever's publishing, et cetera, newspapers, they have editorial authority. They're expected to check and verify and stand behind their content. Versus distributors, which is how now we're defining these large social media platforms. So the Facebooks, the Instagrams, something came up today about some communications over Telegram, any of these big platforms where people are posting, and people can post anything they want. You're saying, okay, they're not liable, and everybody knows about these. They're, if you're posting goods on eBay, if you're, all of your Facebook stuff, all of your, top communications on Clubhouse, et cetera. Section 230 is a defense. So if somebody comes after the company and says, Facebook, my daughter's, losing all this weight because she's following the diet trends on Instagram, or I joined, XYZ club that's terrible or something. Anyways, or I follow the health disinformation. The platform can say, we didn't say to do that. We're the neutral platform. It's a defense to that plaintiff's claim. You have to go after the person who made that post, who made that comment, who did that, influenced you in that way. So that's what 230 is. And it's not a universal defense. There are exceptions. So certain illegal behaviors, they can't post infringing content, which is where you have the DMCA takedown notices. So that's like where eBay has to actually monitor. If you tell eBay that there's something up there that is, counterfeit, they have to pull it down. They have to look and pull it down. And they're allowed the exception so there's light moderating going on. And the clause in 230 that enables that is called the Good Samaritan. So there's expected to go. And that's why you have all this Facebook moderation, right? They're going in and trying to take down stuff that's lewd, lascivious, defamatory, et cetera. So they're doing that light moderation. So that's what all these platforms are standing behind. And as they've grown, we've kind of outgrown 230 as the protection, right? Because now these guys have zero liability to date. And that's why you're hearing this front and center constantly. And it has to do with privacy, influence, disinformation. I mean, around COVID, it really hit front stage. But it's also to do with things like behavioral advertising. These platforms live on advertising, and they are tracking you. So back to privacy, they're tracking you and sending ads, behavioral, highly influential ads or information influencing us in different directions. And that's all protected behind 230. So and again, layering in with the privacy laws, but these are the things that go on in these platforms. So that's where it is now, and it's a big hype because there's a lot of disinformation. There's a lot of impact from this. you can actually tie it back to security because you're looking at it. China and Russia releasing bots and releasing disinformation or hyping disinformation and creating tribes and chaos over here.
Mhm.
They don't care which way you vote or what you think, as long as you tribalize and create chaos and don't like each other. And that's a bit of asymmetrical warfare going on, right? So people need to be, it's a big concern that really isn't, again, being brought to people's attention, or people don't understand as well. You know, you can always go find the data that supports your opinion. But so that's where 230 is now. It is a defense that people are looking at.
Yeah. How are they? What have you been hearing? Because you're more spun up on it than I am. I know there for a while they're looking at holding the organization accountable for all content that goes through. So if somebody is posting hate content or disinformation, now Facebook is being held liable for it. I personally don't see that working. And that also starts infringing, like you said, freedom of speech, other areas. But what are personally you, Jennifer, what are your thoughts on how we could better approach this to start better securing our social media platforms?
Yeah, so I would say in this world where we are now, so again, you can't hold them completely liable. And free speech is someone's right against government action. Government can't stop you, but there's principles, right? It's a value. So this is where people say, if they start moderating too much, it's against my free speech and it becomes censorship. And that's the big issue. And this is where like Trump is saying you're censoring me. Well, maybe because it's not true. But anyways, so that said, my view on this is that what should be step one, clearly regulated, even without changing 230, is that algorithms. People, it's not what I post. It's that what I post, if I post something nicey, it's going to sit right there and not even go in your feed. If I post something salacious or inflammatory, it's going to get amplified because that's eyes on screen. And that's done via algorithm. And it's not that the algorithm is going, let's go find disinformation and amplify it. What the algorithms, well, they're doing all kinds, who knows, they're doing a lot of things, but what they're doing is salacious negative content people do engage with it more. They will comment on it. They will, retweet it, do whatever. But the algorithms are amplifying that and influencing and sending people in directions. And that act of the algorithm should be regulated as moderation. And the more you amplify or the more impact your algorithms have, they should be considered moderation, which would then negate your 230. If you over moderate, you do not have that 230 defense.
Mm-hmm.
So that's where I would go. And that's a very simple one. It's not simple. That's an obvious one.
Yeah.
This really is moderation. Algorithms are moderation. And you're seeing some discussion around this, but not enough. And again, from the Frances, the whistleblower at Facebook, she's like, you guys aren't going to understand this. She's not calling people idiots, but she's just saying this is so complicated, these algorithms, how this is done. Legislator, let us help you.
Yeah.
Hire the data scientists who worked on this stuff so we can explain it to you, because it really is these algorithms, and they can again have unintended consequences. Everybody knows the YouTube ones where the algorithms are designed to keep eyes on page, is how they work, and people like negative content, so it's going to amplify negative content. So regulating algorithms, and there was one proposal to regulate them as to remove behavioral advertising, because again, that's effective. People think that they see it and they're not being influenced. It's not just advertising for products or sales. It's values and perceptives and who you are and tribes. Like, hey, so-and-so's taking your job. People coming over the border are taking your job. You should do X, or join this group over here and do Y. You should go riot the Capitol on January 6th. I mean, there's a lot of influence that people don't see that they're subject to or influenced by. So that's where I think we should go. And then really quickly, do you want me to tell you what some of the other proposals are that are hilarious?
Well, we're actually about to wrap. Can you do it in like 30 seconds?
1 second. So you're allowed to regulate, certain lascivious, comments, etc. There are several bills to like take one word out of what they're allowed to, what they can moderate. So they want to remove content that is obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. They want to take out otherwise objectionable, or they want in good faith to be objectively reasonable. So our legislators are spending time and proposing bills, and those are the only changes they're making. That has zero effect. These are again, I hate to say it, but I hate paying taxes because this is what I'm paying for. These guys and their whole teams are writing something that's going to have these are their proposals. Yeah. So, and there are some to regulate algorithms. I want to fully promote those. But yeah, awesome.
So Jennifer, are you going to run for political office? Oh shoot, I just removed you. Come back. I don't want to be front and center. Well, I don't know why I even hit that. It was right above the one I wanted. So are you going to run for a political office?
No way in hell, man. Have you ever been inside that machine? I work for a lobbying company. That's a machine that you do not want to be in. You will never get anything done.
Yeah, no, I like to support individuals in the congressional seats, but I feel like you can get so much more done where we're at than you can being in that seat. Yeah. All right, Jennifer, before I take you off the stage and do a wrap, final thoughts that you want to share with the viewers. We've had a great show, got up to about 15, 20 people in here. So this has been awesome.
Thank you. Thank you. Thanks, audience. Thanks, everybody. I love everybody's participation. I'm going to tie back to what you said in the beginning, that the support and participation, because I think the security community and these people around this are one of the more inclusive communities I've ever met, definitely more so than like straight attorneys. Yeah. And super give a lot of time and resources to educate and help each other and coordinate and do this. So my final thoughts are to keep doing that, keep bringing more people in, be super inclusive. Yeah. And educate, spend time. Join. I love this community.
Yeah, join and support. Why did I do that again? I've never done that. I've done it twice with you. Done it twice with you. So weird. Okay, so now I've got your information below for your LinkedIn. Is that the best way that people can reach out to you?
Absolutely, and please do.
Cool. We're going to be definitely having you come back on this show because I think there's going to be a lot of things kicking off here this year alone, because I think some things are going to kick off with some of our adversaries, and we're going to have to start being reactionary with our laws. When that happens, be prepared. Bring you on the hot seat, Jennifer. Right. You've been awesome.
Right.
Thank you so much for coming on the show.
Thank you. Thank you for having me. It was super fun. Thank you. Bye.
Wow, you guys. So that was awesome. I'm a big nerd in this space, so I was looking forward to that. If you guys like the episode, make sure to comment below. Also, reach out to Jennifer if you have any questions. She's a great resource. Also, if you're ever on Clubhouse, they do a Clubhouse night. It is on, today's Thursday, so I didn't want to share that right away. I'm having click happy today. So it's on Wednesdays at 6 p.m. There's a Clubhouse room, and I just spaced it. Tom, if you're still in the chat, drop your Clubhouse room in there so everybody knows how to get in there. Jennifer's always in there chatting it up. It's always a great time. I love it. It's about an hour. So let's talk about next week really quick. So next week, I don't know why this is doing this. Can you guys see this? Or is it making it all green on your end? Is it green? Oh, it is green. I don't know why it's doing that. So weird. Okay. Well, hold on. Let me do this. Let's try to do it this way. No, weird. Look, it's like greening it out. Okay, so next week, we won't worry about that. Next week, we've got the GRC panel. So super excited about that. That's going to be with Erica McDuffie. We've got Jacob Horn, Dr. Gerald Ogier with Simply Cyber, and Linda Russ. It's going to be awesome. It's going to be from 3 to 4 p.m. Eastern Standard Time. We're going to be digging into some of really hard GRC questions. So definitely come with your questions to this panel. You're not going to want to miss it. I really feel like it's going to be super dynamic. And then really quick admin thing for anybody that was on the call earlier, maybe wasn't on the call earlier and now you are, not call. I've done way too many phone calls today on the live stream. We hit 400 subs today. So thank you all for subscribing. I am looking for a subscriber. His name is Lost in IT, and she was number 400. Whoever you are, reach out to me. I have got a gift for you. I'd like to get that to you. And then just a reminder, as of right now, we do weekly shows. They drop every Thursday from 3 to 4 p.m. Eastern Standard Time, unless something comes up. So make sure you subscribe. If you like this episode that we did with Jennifer, make sure to hit that like button and then go ahead and share it with others. I will see you all next week on Thursday for our GRC panel. Thank you, everybody. Bye.